Good morning, everyone. It is July 17th, 2019, and it is Snoop4Truth Wednesday. Had to give Snoop a little spy music. All right, enough of the fun. Okay, you guys, we're going to be going over some things that I think you're all going to find very interesting here. Snoop4Truth has dug up some information on right to travel without a driver's license that is going to blow your mind. There are some things that really no one has addressed before with regards to a lot of these people that are out there spreading this actual hoax. Now, before I get too far into this, I want to mention this about why it is that these groups are spreading this hoax, and they're taking such great, they're going to such great lengths to attempt to try to get people to believe this. Contrary to popular belief, it isn't just a matter of making money. There are reasons behind these movements. There are reasons why these sovereign citizens don't want for people to follow the law. It ties up the courts, it ties up the cops, and it spreads anger amongst the people. So it keeps people polarized, we'll say. It keeps people in a state of anger at the government. It keeps people submerged in misinformation that's going to follow them, because chances are, unless they see something like what we're doing here on Snoop4Truth, they're not going to ever understand why it is that the government or the cops or the judges that they go into traffic court and see are going to tell them. They're not going to get it. It takes a lot of research and a lot of understanding of the real law in order to be able to locate where and why these regulations are actually fact. And that's where you run into scenarios where these people that are the YouTube lawyers, okay, have problems because they don't know the entire law. They don't know, and nor do they care to look up anything that goes against their narrative. They don't really give a damn one way or the other, because the point is to try and find ways to tie up the court through bogus paperwork, tie up the cops through misinformation that's provided to those that are driving, that get pulled over and think they can drive without a license. The whole point of the movement is to slow the government down to a grind. And that just is what it is. It isn't just a matter of scamming people for money, although they do that too. The whole purpose is to create a general nuisance, and eventually they're hoping anger enough for an uprising to overthrow the federal government. All right, what I'm going to have you do now is I'm going to have you actually take a look at some clips that are done by a gentleman by the name of Eddie Craig. Now, Snoop4Truth has been nice enough to give us these, the actual sections of these clips. I'm going to show them to you one at a time, and then I'm going to go over the actual laws and why it is that he is giving you false information. And, well, I've already pretty much told you why, but I'm going to give you information as to how it is false information and where you can look up the information that's factual should you want to see it. I'm going to show it to you, and when you see this, you're going to realize, really, everything that he says in this full 2.5-hour presentation is all bullshit. I don't want to miss telling you guys where to locate this information. First of all, you will see that this is the Belligerent Politics channel. This actual video was made in 2013 by a gentleman by the name of Eddie Craig. It's called What the Government Doesn't Want You to Know About Your Driver's License. You'll notice that there are over 29,000 subscribers, and look at the amount of views. And every single day, there's more and more and more going on here. Almost 1 million views of misinformation, and we wonder why we keep seeing videos of people being arrested and their windows being smashed in. This is the kind of misinformation, and keep in mind, this is only one out of hundreds of individuals that are spreading these lies. Let's take a look at Eddie Craig, clip number 1.
Motor Vehicle Code and Transportation Code is based upon the federal law. The federal law itself is specifically directed at commerce. It's the only thing the federal government can regulate in that realm is commerce. Well, folks, I'm here to tell you the same thing is true for your state government. They cannot regulate your private activity. They can only regulate the commercial activity that has an opportunity or ability to affect the general public. This is what is known as a regulable activity. A regulable activity is any activity where one must have a license.
Here is Eddie Craig's clip number 2.
Real briefly, I just want to show you that there is tons of case law on this subject. Again, this is an excerpt out of the chapter 2.2 of my book on the Texas Transportation Code, and it is full of case law. Since the very invention of the automobile to current, there's been case after case after case at state and federal level that specifically says that there's a distinct difference between commercial use of the roads and the right of the people to use the road for non-commercial purposes. One is a privilege, the commercial. The other is a right. It is a right of living.
Here is clip number 3.
Defined as something specific to transportation. And as we saw early on in the definition of transportation, that's a commercial activity. Everything about the Transportation Code is commercial. You can't find anything in it that makes it anything other than commercial. Though it doesn't spell it out in plain, clear language that it's commercial only, the fact that it's a transportation code tells us what its subject matter limitation is.
Here is clip number 4.
Sign is. And again, it's not to regulate the general public. It is to regulate those engaged in the regulable activity of transportation for commercial purposes. What proof do I have of this argument? The statute. When we look at the statute, you see section 201.904, which is out of subchapter K, Road and Highway Use regarding signs. 201.904 is titled Speed Signs. And it reads, "The department shall erect and maintain on the highways and roads of this state appropriate signs that show the maximum lawful speed for commercial motor vehicles, truck tractors, truck trailers, truck semi-trailers, and motor vehicles engaged in the business of transporting passengers for compensation or hire," meaning buses. So folks, how much plainer can you get about what's being regulated by a speed sign? Everything in this definition is commercial. Everything. Nothing has to do with the private car. Nothing. The difference here is what's being referred to. Vehicles, 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 drivers, operators. Those are what we're talking about. All of those are things that are regulated for the purpose of transportation, which in and of itself is the commercial activity being regulated by this code. These are the little things that the courts and the prosecutors and the money machine doesn't want you, the general public, to know or understand. Well, I'm here to tell you it's a lie. It's been a lie for a long time, and the money that has been stolen from us is egregious in nature in its sheer amount.
Clip number 5.
That you had it. That's a problem. Now, On top of that, they know that this deals with a commercial activity known as transportation that the state can regulate, but at no time have they alleged or brought any proof that you were somebody engaged in that activity. So how can you be guilty of an offense under a statute that has absolutely nothing to do with you unless you're engaged in that regulable activity known as transportation? You don't use the roads as a place of business, yet you're being charged under a statute that applies only to that special group of people and individuals who are. It's theft, it's fraud, and you need to know it. Let's go to the next section.
And finally, here is clip number 6.
If you can name a single government-issued license or permit that is issued for any purpose other than engaging in some commercial activity for compensation or hire. When you start thinking about all the governmental licenses and permits that exist, if you think about how it's applied at every point and used at every point, it will eventually dawn on you where the commercial aspect of that license or permit pops up its ugly head. All of them are.
Okay, so the link for this is going to be in the description of this video. This is the Annenberg Guide to the United States Constitution. We're looking at Article 1, Section 8, and we're going to be looking at Clause number 3, where it states very clearly to regulate commerce with foreign nations and among the several states and with the Indian tribes. One more time. To regulate commerce with foreign nations and among the several states and with the Indian tribes. Okay, so what we're looking at now is the Legal Information Institute for Cornell Law School, and what I'm showing you here is this is considered the Commerce Clause. Okay, the Interstate Commerce Clause. It refers to Article 1, Section 8, Clause 3 of the U.S. Constitution. So I'm going to go ahead and link this in the description of the video in addition. This clause empowers the federal government only to regulate driver's licenses only if the driver is engaged in commerce between the several states called interstate commerce. On the other hand, the 10th Amendment reserved to the states the power to regulate driver's licenses in all other contexts not delegated to the federal government in the U.S. Constitution, including driving while not engaged in interstate commerce. This is the 10th Amendment information from the Annenberg classroom that will be linked in your description area that you can take a look at. 1941 states, in a switch from its earlier pro-states' rights rulings, particularly Hammer versus Dagenhart, the U.S. Supreme Court rules unanimously in United States versus Darby that the federal government acted within its authority in passing the Fair Labor Standards Act, FLSA. The court finds that the law, which establishes numerous minimum wage and maximum labor standard nationwide, falls within Congress's authority to regulate interstate commerce. This is why the states can regulate driver's licenses only if the driver is not engaged in interstate commerce. But Eddie Craig does not know enough to realize this. Unknown to Eddie Craig, the U.S. Constitution divided the powers, divided legal jurisdiction between the federal government and the state governments. This division of powers, division of jurisdiction, was based on legal subject matter. The U.S. Constitution only empowered the federal government to regulate a tiny list of legal subjects that were expressly delegated to it in the U.S. Constitution. The 10th Amendment reserved to the states the power, the jurisdiction, to regulate everything else, all other legal subjects not delegated to the federal government in the U.S. Constitution. But Eddie Craig does not know enough to even realize this. Here's a simplification. Under this constitutional division of powers, or division of jurisdiction, between the federal and state governments, a legal subject must either be regulated either by federal law or by state law, but not by both. So if a legal subject is governed by federal law, it is not governed by state law. Likewise, if a legal subject is governed by state law, it is not governed by federal law. As a result, federal and state governments do not regulate the same legal subjects. They regulate the opposite legal subjects. But Eddie Craig does not know enough to realize this. The purpose of this constitutional division of powers was to ensure harmony between federal and state governments by dividing between them the legal subjects that each was empowered to regulate. But Eddie Craig does not know enough to realize this. Thus, contrary to Eddie claims false claims, in this first clip, again,
Motor Vehicle Code and Transportation Code is based upon the federal law. The federal law itself is specifically directed at commerce. It's the only thing the federal government can regulate in that realm is commerce. Well, folks, I'm here to tell you the same thing is true for your state government. They cannot regulate your private activity. They can only regulate the commercial activity that has an opportunity or ability to affect the general public. This is what is known as a regulable activity. A regulable activity is any activity where one must have a license.
It's not true that the state traffic and transportation codes are based on the federal traffic and transportation codes, because federal law and state law regulate opposite legal subjects. For an expert explanation of these basics of constitutional law, read the first 11 paragraphs of the 6th comment that's located underneath the description of this video entitled 11 Paragraphs. Here's the conclusion. If you are a driver that's engaged in interstate commerce, then you are governed by federal law, which requires you to have a driver's license to drive a motor vehicle. If you are not a driver engaged in interstate commerce, then you are governed by state law, which requires you to have a driver's license to drive a motor vehicle. Either way, a driver's license is required to drive a motor vehicle. But Eddie Craig doesn't know enough to realize this. So if you're a driver who has successfully proven to law enforcement officers and or to the courts that you were not engaged in interstate commerce as Eddie Craig recommends, then you have just conclusively proven that you are governed by state law, which requires you to have a driver's license to drive a motor vehicle. But Eddie Craig does not know enough to realize this. The actual real law itself on this subject is, as we go along here, going to be shown to you. Because I want for you guys to actually be able to have all of the case law that proves that there's 100% failure rate with this theory that Eddie Craig is pushing. Over a century ago, the Supreme Court held that the states had the right to require all drivers of all motor vehicles to have driver's licenses, whether or not the driver was engaged in interstate commerce, exactly opposite to what Eddie Craig falsely claims. Let's take a look at Hendrick versus the state of Maryland. And these will all be in the description below, folks, if you want to read the whole case, but I'm going to summarize each one for you. In this case, the United States Supreme Court held a state may rightfully prescribe uniform regulations in respect to the operation upon its highways of all motor vehicles, those moving in interstate commerce, as well as others not moving interstate commerce. And to this end, the state may require the registration of such vehicles and their licensing of their drivers. This is but an exercise of the police power uniformly recognized as belonging to the state under the 10th Amendment in the 8th paragraph at about 70% through the text. This decision above is from the highest court in the United States. This court is the only court in the United States which has the power to overturn this decision, but it has never been done. That means the decision still the single controlling law on this subject in every state and every federal jurisdiction in the United States. So if you find any decision from any court anywhere in the United States which contains any language of any type which you interpret as preventing the states from requiring drivers of motor vehicles to have driver's licenses, then you have interpreted that other decision wrong. There has never been any decision from any court in the United States which holds states may not require drivers of motor vehicles to have driver's licenses, but even if there were such a decision, this decision would overturn it. Since this decision, Congress, in compliance with this decision and in compliance with Article 1, Section 8, Clause 3 of the U.S. Constitution, passed national federal legislation regulating only those drivers who were engaged in interstate commerce, Title 49, under the 10th Amendment, and under this decision, this reserved unto the states the power to regulate only those drivers who were not engaged in interstate commerce. In this sense, federal law and state law are now opposites of one another. But Eddie Craig does not know enough to realize this. In this 2004 case, we're looking at L versus Richmond police officer Opdyke. In this case, an amateur legal theorist unsuccessfully sued an officer who arrested him at a traffic stop. The case reads that L, the Moore, acknowledges that he does not have an active driver's license, but contends that if a person is not engaging in commercial activity on the highways and byways, that person does not need a driver's license to travel in his own private property. A false claim identical to what Eddie Craig also falsely claims. At the third paragraph, at about 30% through the text, but the court held otherwise and wrote, "The Supreme Court has stated the use of the public highways by motor vehicles with its consequent dangers renders the reasonableness and necessity of regulation apparent. The universal practice among the states is to register ownership of vehicles and to license their drivers. Any appropriate means by the states to ensure competence and care on the part of its driver's licenses and to protect others using the highway is consistent with and complies with due process." Notably contrary to the false claims of Eddie Craig, the Supreme Court did not limit its holding in this regard to commercial uses of public highways. At the 12th paragraph, at about 70% through the text, and again, these are in the description, guys. You can take a look at them as the video is going if you would like to watch it again. Translation: contrary to the claims of Eddie Craig, the states are authorized by the U.S. Constitution and by the Supreme Court to require drivers of motor vehicles to have driver's licenses, and that rule is not limited to drivers engaged in commerce. It is the federal government, not the state governments, whose driver's license regulations are limited to drivers engaging in interstate commerce. But Eddie Craig does not know enough to realize this. Our next case that we are looking at is Scalpi versus town of East Fishkill. And in this case, a amateur legal theorist sued a town and government officials for her many arrests for driving without a driver's license. The case reads, plaintiff, the amateur legal theorist, for lack of a better phrase, maintains there is no law making a driver's license mandatory unless operating a vehicle for profit, meaning for commercial purposes. but the court held otherwise and cited the following holdings from other cases with approval. The power of the state to regulate the use of its highways is broad and pervasive. Citation omitted. A state may prescribe regulations related to the operation of motor vehicles on its highways, including registration and licensing requirements. An individual does not have a fundamental right to drive a motor vehicle. It is beyond dispute that states may impose driver licensing and vehicle registration requirements upon their citizens. The Constitution does not recognize a fundamental right to drive. Notably, the Supreme Court has held that states may constitutionally regulate the use of public highways without limiting that rule's application to commercial use of public highways. At the 17th paragraph, about 60% through the text, you can find this translation. Contrary to the claims of Eddie Craig, the states are authorized by the U.S. Constitution and by the Supreme Court to require drivers of motor vehicles to have driver's licenses, and that rule is not limited to drivers engaged in commerce. It is the federal government, not the state government, whose driver's license regulations are limited to drivers engaging in interstate commerce. But Eddie Craig does not know enough to realize this. Okay, we're looking now at a case that is called Triemert versus Washington County. And in this case, we have a party that sued the county and others for issuing him a ticket for driving without a driver's license. The case reads, quote, the gist of Triemert's legal theory is that the definition of driving in the irrelevant United States Transportation Code, USTC, and all state transportation codes derived from the USTC, imaginary codes which do not exist, refers to persons who are licensed by occupation and operating a motor vehicle in commerce engaged in the commercial purpose of hauling freight/cargo or passengers or both, a claim that is identical to what Eddie Craig also claims. When he was arrested, he claimed that he was not driving or operating a vehicle or engaged in any commercial activity or for the purpose in hauling or freight or passengers, according to this definition, referring to the irrelevant federal law. Additionally, he claimed that the irrelevant federal code defines motor vehicle as a contrivance used for commercial purposes, citing irrelevant federal law. Finally, Triemert claimed he was not driving in a private automobile, nor a motor vehicle, when he was unlawfully stopped and arrested, but the court disagreed and dismissed Triemert's lawsuit. Translation: contrary to the claims of Eddie Craig, the states are authorized by the U.S. Constitution and by the Supreme Court to require drivers of motor vehicles to have driver's licenses, and that rule is not limited to drivers engaged in commerce. It is the federal government, not the state governments, whose driver's license regulations are limited to drivers engaged in interstate commerce. But Eddie Craig does not know enough to realize this. So the next case that we're looking at is Spokane versus Port. This case reads as follows. The officer asked Miss Port, an amateur legal theorist, for her driver's license 6 times. After she refused, Mrs. Port was arrested for refusal to give information, no valid operator's license, and for resisting arrest. At the second paragraph, at about 25% through the text, which you guys will be able to take a look at yourselves in the description below, Mrs. Port claims the state licensing statute applies only to commercial operators of motor vehicles. She claims since she was not engaged in the business of transportation, she did not violate the state driver's license law, a false claim identical to what Eddie Craig also is falsely claiming. At the third to last paragraph, about 90% through the text, but the court dismissed and wrote Mrs. Port's argument that the state driver's license law requires a license only for those operating commercial vehicles is clearly without merit. The state driver's license law defines an operator or driver as every person who drives or who is in actual physical control of a vehicle. Translation, commerce has nothing to do with it. Since Miss Port was in actual physical control of her vehicle when stopped, she came under the provisions of the state driver's license laws. At the final paragraph, at about 95% through the text, translation is contrary to the claims of Eddie Craig. The states are authorized by the U.S. Constitution and by the Supreme Court to require drivers of motor vehicles to have driver's licenses, and that rule is not limited to drivers engaged in commerce. It is the federal government, not the state governments, whose driver's license regulations are limited to drivers engaging in interstate commerce. But Eddie Craig does not know enough to realize this. Next, we have Taylor versus Hale. In this case, an amateur legal theorist appealed the dismissal of his lawsuit against the judge who presided over his conviction for driving without a driver's license. The court wrote, plaintiff, an amateur legal theorist, appears to contend that he cannot be required to obtain a driver's license because he was not operating a motor vehicle for a commercial activity, a false claim that, as you have seen, is identical to what Eddie Craig is falsely claiming. The plaintiff claimed that he was merely traveling. He claimed that the state can only regulate commercial activity through the requirement of a driver's license, but not traveling, a false claim identical to what Eddie Craig also falsely claims. He contends that the term operate means and refers to someone engaging in commercial activity in the state, a false claim identical to what Eddie Craig also is falsely claiming. The plaintiff's argument is that because he was traveling and not engaged in a commercial activity, he did not operate a motor vehicle and was therefore not required to have a driver's license, a false claim that is, of course, identical to what Eddie Craig also has falsely claimed. The court concludes that plaintiff's argument is without merit. The court concludes the plaintiff's argument is without merit. That the plaintiff can argue that he was not operating a motor vehicle but merely traveling strains credulity. Plaintiff was traveling, but he also was operating a vehicle. Otherwise, this would mean that the vehicle operated itself and took a round trip from Dallas to Lake Jackson without any act performed by plaintiff operating, as the word is used in the state driver's license law, does not refer to commercial activity. Let me read that again. The state driver's license law does not refer to commercial activity. To the extent that the plaintiff asserts that the license requirements interferes with his right to travel, such argument is without merit. Requiring one to obtain a license to operate a motor vehicle on a state public highway is not an impermissible or undue burden on interstate travel, ensuing that one can safely operate a motor vehicle and is familiar with the traffic laws is a legitimate exercise of a state police powers and presents no constitutional impediment to the right to interstate travel. I'm supposed to read that again, you guys. Okay. So, interstate travel ensuing that one can safely operate a motor vehicle is familiar with the traffic laws is a legitimate exercise of a state's police powers and presents no constitutional impediment to the right to interstate travel. Translation. Contrary to the claims of Eddie Craig, the states are authorized by the U.S. Constitution and by the Supreme Court to require drivers of motor vehicles to have driver's licenses and that rule is not limited to drivers engaged in commerce. It is the federal government, not the state governments, whose driver's license regulations are limited to drivers engaged in interstate commerce. But Eddie Craig does not know enough to realize this. Are you guys starting to get it yet? Because I've got several more cases to go here. But I think what I'm going to do is go over one more with you guys, which is Williams versus Rice. And then what I'm going to do is I'm going to let you guys look at all 15 for yourselves. The point being here, obviously, that interstate commerce is governed by the federal government, not the state. So you're barking up the wrong tree entirely by looking at state codes. The state governs people driving automobiles as a traveling source. The federal government is who regulates commerce. So all of the arguments of Eddie Craig's and everybody else's who spews this lie are thrown out the window, because the states don't deal with commerce at all. Okay, you guys, so we're looking at the very last one that I'm going to do, which is the 8th one, by the way, and I've got a total of 15 here for you guys to look at. There are tons more. The bottom line is that everybody who tries this fails, and it's because they don't realize that very simple fact. That the federal government is who regulates commercial and interstate, or commercial interstate commerce, not the states. The states have the right to regulate regular citizens. They have the right to regulate it in all ways. The states don't have anything to do with interstate commerce part of it at all. That's federal. So this is where they keep running into problems. So Williams versus Wright. In this case, Williams is an amateur legal theorist who filed a claim in federal court effectively seeking reversal of his state court conviction for driving on a suspended license. Williams was convicted and was sentenced to serve 6 months in prison. In this case, Williams claimed that the state court erred by deciding that he was required to possess a driver's license when he was not involved in commerce upon the highway, a false claim that's identical to what Eddie Craig also falsely claims. But the appellate court disagreed and dismissed Williams' lawsuit. At the 4th paragraph, about 45% through the text, and contrary to the claims of Eddie Craig, the states are authorized by the U.S. Constitution and by the Supreme Court to require drivers of motor vehicles to have driver's licenses, and that rule is not limited to drivers engaged in commerce. It is the federal government, not the state governments, whose driver's license regulations are limited to drivers engaged in interstate commerce. But Eddie Craig does not know enough to know this. All right, so here's what I'm going to do, you guys. What I'm going to do is give you all of this information on this specific topic, because there's going to be a part 2 next Wednesday that's going to cover even more broadly of this issue. I'm going to put, with Snoop4Truth's help, the right to travel argument in the grave where it belongs. Okay, you guys, so to close this out, let me just say thank you so much to Snoop4Truth, because this delves even deeper into the right to travel argument. And this is going to be, this is just part 1 of 2 parts that are going to blow the rest of the argument out of the water that these sovereign groups have been lying about for years and years and years now. I would love it if everybody would share this video, because even though it's a little bit lengthy, it's about 30 minutes long, it's chock full and packed with information that absolutely proves where the misconception is with regards to commerce in driving with a driver's license and right to travel that has nothing to do with what they think it does. This is the problem with people who think they know the law because they pick up a Black's Law dictionary. So let me just say that to anybody who can find a way to share this on social media, it would be greatly appreciated. One more time, thank you so much to Snoop4Truth for helping to locate all of this wonderful case law for everybody to take a look at, and for addressing this subject matter in such a way that made it easy for people to listen to and understand. All right, everybody, we'll see you again next Wednesday with part 2 of Right to Travel and the No Driver's License Needed hoax next Wednesday on Snoop4Truth part 2. Bye-bye.